oh yeah, these terrible fellows. They're not a licensed medical doctor. They have no knowledge, experience, expertise. They can't add anything to this case. And
Good afternoon, Your Honor. Nicholas Hoffman again for UNFW. Mr. Pepperman went a little bit outside of the briefing on this motion. He brought in some new exhibits and whatnot. I'm actually happy he did because I think that they prove our point. But before I get to that, Your Honor, the one thing I really want to emphasize at the outset is that Mr. Pepperman admitted the key facts for this motion. So to be clear, this motion is not about the epidemiology or general causation aspect. This motion is about medical causation and Dr. Freeman's lack of qualifications to render medical causation opinions. And the court heard Mr. Pepperman admit that Dr. Freeman has no medical license. He has not even done, right now if he wanted to apply, I mean, Mr. Pepperman admitted that he could not practice here in the United States. He'd have additional tests or requirements to do if he did want to practice medicine here. Mr. Pepperman admitted that he's not a medical doctor. He admitted that he does not treat patients. So he does not treat patients here in the United States. He does not diagnose patients for any medical conditions. That's what he's trying to do in this case. Your Honor, we think that this falls squarely within the Williams case, and it's the exact same as that Nurse Hambrick attempting to render medical causation opinions. Dr. Freeman is simply not qualified to render the medical causation opinions that he's trying to offer. Now, Mr. Pepperman also mentioned the case of Fernandez versus Admiran. And I would just note, and we explained this in our reply, the Fernandez case deals with the situation where an expert is a physician who is qualified to testify as a physician, and then it stands for the principle, which isn't really relevant here, but it stands for the principle that once a physician is qualified to testify, he or she is given wide latitude to testify about other diagnoses and whatnot, since a lot of physicians know those other areas. Well, we skipped a step here. So Dr. Freeman is not a physician. Even Mr. Pepperman admitted that Dr. Freeman is not a medical physician here, Sweden, anywhere in the world, and he certainly is not qualified to act as a physician here or to treat patients or to diagnose medical conditions. Now, Mr. Pepperman also suggested that we are citing only Dauber cases, and I want to be very clear on this. I'm going to skip back through this PowerPoint, and this is something that
you don't have to explain that. I mean, I understand the distinction. In fact, Nevada's law said you can look to Dauber sometimes, for similarities. I get it.
Correct. And, I want to be very clear, we're on Hallmark. So, and I just want to put this on the screen. I know the judge knows it well, but, for Hallmark versus Eldridge, in determining whether a person is properly qualified, a district court should consider the following factors: formal schooling and academic degrees, number 2, licensure, number 3, employment experience, and number 4, practical experience and specialized training. Now, it's undisputed that here, Dr. Freeman does not have licensure to be a medical doctor, he does not have employment experience to be a medical doctor, and he does not have the practical experience or specialized training to be a medical doctor. Now, I guess Mr. Pepperman's arguing that he has formal schooling that it's not even clear that that's to become a doctor. And in fact, I have transcripts from those other cases where he was excluded, and he explains to the judge in those cases that he's not a medical doctor and is actually training for a PhD, and that Sweden just calls the med.doctor degree either a PhD or a med.doctor degree interchangeably. But in any event, under Hallmark, at best, Dr. Freeman has perhaps, maybe, an unproven 1 out of 4 of these. He certainly does not have the other 3, and so, under Hallmark, he is not qualified to render the medical causation opinions, the specific causation opinions that he's attempting to render here. The other critical component of Hallmark that I know the court knows well is that An expert's qualifications must match the opinions the expert is attempting to provide in the case. An expert may only testify to matters within the scope of such knowledge. So Mr. Pepperman got up and he did a little bit of a sleight of hand here. You know, he spoke about the credentials of Dr. Freeman for epidemiology and for general causation, and you know, his biomechanical experience, and you know, these other cases he testifies in. But then he suggested that he's such an esteemed expert and so well qualified for those areas that he should apparently be able to testify about everything, including the medical causation opinions that he's trying to render here. That's not how the law works. So Hallmark is very clear that the scope of the expert's testimony must be limited to where he or she actually has the actual expertise, where he or she has those qualifications. And here, it's very clear that Dr. Freeman does not have the qualifications or expertise to render these types of medical causation opinions. He has, you know, no qualifications to, for instance, diagnose hepatitis, or to say, or to rule out if something came from, you know, hepatitis versus something else. So that is just not something that was in his scope of knowledge, and per Hallmark, that needs to be excluded. Now, I mentioned at the outset, I was happy that Mr. Pepperman brought up the MMWR. So, John, if you can put that on the screen. And Your Honor, as I said, this is not in the briefing, it was not in plaintiff's opposition, but I think this proves our point. So, UNFW is seeking to exclude Dr. Freeman's medical causation opinions about two of the plaintiffs, Keith Haley and Richard Belsky. Now, Mr. Pepperman went through this explanation, which is this, you know, epidemiology investigation by the CDC in the Southern Nevada Health District. And what he neglected to tell the court was that this only related to the probable and suspect cases. So this did not relate to Keith Haley or Richard Belsky. It is undisputed that Keith Haley and Richard Belsky were not investigated by the Southern Nevada Health District. They were not classified as probable nor suspect cases by the Southern Nevada Health District. And so there is no evidence from the Southern Nevada Health District that they became sick or that anyone in their situation became sick from real water. And in fact, when asked about these types of cases at the deposition, the Southern Nevada Health District epidemiologist said she was unaware of any cases or outbreaks of hepatitis prior to August 2020, and that if she had any evidence whatsoever, that she would have extended the search beyond August 2020, but she had no evidence whatsoever. She had no reason to believe that Keith Haley nor Richard Belsky were actual cases of injuries linked to real water. I want to show the court a couple additional slides. John, if you would go back to that, I guess I can't change it, I might have to tell you. If you could go to, I think it's slide 22. So, Your Honor, for instance, Mr. Pepperman didn't show you in this exhibit that he put up that the CDC explained that all patients with probable cases and 3 out of 4 of the suspect cases consume the 5-gallon product. The CDC thought there was a link here with 5 gallon. Now, John, if you could keep going down the slides, and I'll tell you when to stop. Going. All right, let's stop here. So, Mr. Pepperman had showed this to the court, same exact PowerPoint that he showed you. The CDC, FDA, and Southern Nevada Health District found it important that there were 2 real water facilities at this time, one in Henderson that distributed only the 5-gallon product, and one in Mesa, Arizona. John, go to the next slide if you don't mind. Here, the CDC is explaining that, if Your Honor will see that red shading on the slide, the red shading is the geographic distribution area for the 5-gallon product. That geographic distribution area, the CDC, FDA, and Southern Nevada Health District found was exactly overlapped with the probable and suspect cases who had the hepatitis connected to real water. So I raise this for Your Honor, and this is very important, because Keith Haley, who's one of these individuals, is not even in that geographic distribution area. And, you know, so Reno, for instance, I don't believe is within that red area. So according to the public health agencies, Mr. Haley, as an example, would not have even qualified for this analysis that Mr. Pepperman showed the court. John, if you could keep going. Here was the distribution area, by the way, that the CDC, Southern Nevada Health District, and FDA documented in retail bottles. It was across the board and obviously far wider than the probable or suspect cases, which were limited only to Southern Nevada and one area of California. John, if you keep going. Keep going. Stop here. So, Your Honor, Mr. Pepperman showed you this slide with these expected odd ratios. And I think this is very important. So he admitted that there were 42 individuals in Clark County during this exact time period who would have qualified as quote-unquote outbreak patients per the guidelines and per all the standards for what was defined as an outbreak patient. There was only one big problem. Those 42 individuals in Clark County during that time period had never ever consumed real water. So they hadn't had a single drop of real water. 42 individuals in Clark County during that time period. 42, in fact, out of 56 individuals. So out of the individuals who had these criteria during the outbreak period, 75% of those individuals, 42 out of 56, never even drank real water. So obviously, Your Honor, those 42 individuals did acquire those symptoms via some alternative cause, whether it be alcohol. I saw on the list that Mr. Pepperman showed you, there's cocaine, there's, Tylenol, there's all sorts of different causes for liver failure. But in any event, I think this is important because it emphasizes that if any of those 42 individuals decided that they wanted to file a claim in this case, and even though they'd never drank real water, and even though it's obvious, because they never drank real water, that they got their hepatitis from some other cause, according to plaintiffs' construct of how they can prove causation in this case, all of those 42 individuals still would have been able to prove causation, and that's not how it should work. Plaintiffs actually need specific causation testimony to be able to prove that the hepatitis for these individuals and the 14 or even theirs that they have outside of these 14 was specifically caused by the consumption of real water or the hydrazine in the real water. That is what they're lacking here with Dr. Freeman. John, if you keep going. Stop here. One back, John. So, Your Honor, plaintiffs have suggested that, and I think Mr. Pepperman set up a bit of a straw man here. He said that we are arguing that they need to prove the exact amount, and I wrote down in quotes, the exact amount of the hydrazine that was consumed by these plaintiffs, and that's not what we're saying. They need to prove that a sufficient amount of hydrazine was consumed by these individuals such that it was a toxic amount. He also suggested that plaintiffs shouldn't have to do this because they don't have the data. But they do have the data. Here's an example. So from the Southern Nevada Health District, CDC, and FDA, there's this data explaining, how much ounces per kilograms per day. They know how much these individuals weigh. They know, presumably, how much real water their clients were drinking. That they need to be able to show if their clients, people they're bringing claims on behalf of, have drank sufficient amount in a way such as using data like this that we do have available. That's something that Dr. Freeman did not do. So obviously the second ground for our motion is that Dr. Freeman did not engage in this type of analysis that we see here from the CDC. Instead, he merely assumed his conclusion. He said that, this individual got sick, and so and if he got sick or he or she got sick after drinking real water, therefore it must have been the real water. That's not how specific causation works. He did not eliminate any alternative causes or anything like that. Now, the other reason why this MMWR and the study that epidemiological study from the health agencies is so important, I think such a good example, is that Mr. Pepperman took you through the MMWR and showed you that there was, from the MMWR for the probable cases, there was documentation of a negative viral hepatitis panel, and there was also a hepatic imaging that did not reveal alternative causes. Well, the MMWR does not relate in any way to Richard Belsky or Keith Haley. So MMWR did not do that for Keith Haley or Richard Belsky. CDC, Southern Nevada Health District, FDA did not do that for Keith Haley or Richard Belsky. The person doing that, apparently for Keith Haley and Richard Belsky, eliminating alternative medical causes and diagnosing their cause, is Dr. Freeman, who does not have a medical license. So I think that their argument will be a little bit different perhaps if they were talking about an actual probable or suspect cases, perhaps Kathleen Ryerson, but that is not what this motion is about. Our aspect, and I understand that the joinders might deal with that, but our aspect of this motion deals with Keith Haley, Richard Belsky. They are non-outbreak patients. There has been no one from the Southern Nevada Health District, CDC, or FDA who has eliminated alternative causes for them. There has been no one from the CDC, Southern Nevada Health District, or FDA who suggested that their liver issues were caused by real water. And in fact, the evidence before the court shows that 42 out of the 56 individuals in Clark County during that time period indisputably had their hepatitis caused by other causes besides real water. Your Honor, in light of this evidence, we do not believe that Dr. Freeman should be allowed to testify as to medical causation. He's both unqualified to do so, and his medical causation opinions under Hallmark are also speculative, unreliable, and of no assistance to the jury. Happy to answer any questions you might have.
I do. I mean, I've been thinking about this. As far as his deposition was concerned, did you drill down deep as far as his qualifications are concerned?
Your Honor, I wasn't at that deposition. I don't
Did
believe
anybody?
I don't believe that there was as in-depth of a discussion of his qualifications as in some of these other cases, I can say. So for instance, I pulled up on Westlaw, we have the full transcript of the evidentiary hearing in that other case that I showed you, and the court asked him specifically, do you have a medical degree? No, I don't purport to. What is your, and he says it's a med.dr degree, which is, in Dr. Freeman's words, akin to a PhD. And he specifically says repeatedly, it's not a clinical degree, it's not a clinical degree. I think he in fact produced his diploma in that case and said PhD on it, if I understood the transcript correctly. So, I don't think that we got into that level of detail, to be fair here. But I was not at the deposition, and obviously I hope someone will correct me if I'm wrong.
And the only reason I ask the question, because I still don't know the answer to all these questions. For example, I'm looking at and I've been thinking about this issue. And I'm looking at his forensic research and analysis. Then I go to page, I guess would be the final page. I don't even know if this is a number or not. It doesn't appear to be. But I think this is where he signs off, and this is his report dated, is it April 20th of 2023?
That sounds right.
Yeah. And here's my question. I mean, for example, I'm still unclear on the training that would, an education that would be required to get a med.dr, whatever that is. I will say this, that I do respect a lot of the different medical disciplines and sciences that come out of Europe, Asia, Africa, South America, et cetera, et cetera. There's a lot of fine physicians come from those different areas. And so that's not really, I think, the real point, but I don't know specifically what that is. But then I looked down and he has a lot of different initials next to his name, like what is an MS, CFMS, MPH, and so on. But then I go down the list and there's a lot listed there, but some things jump out at me. And for example, apparently it appears to be, I don't know if this is true or not, I don't even know what it means, but he's a fellow for the Royal College of Pathologists, right? And the reason why I bring that up is this: I understand pathology is a specific discipline that deals with the cause of and effects of injury and disease. I know what that is. And so if he's a fellow with the Royal College of Pathologists, has anybody asked him that question and what that entails? Do we know?
Your Honor, I don't believe we know that. I mean, and
Don't you think I need to know that though from a qualifications perspective?
I don't, and I can tell you why I don't, because Mr. Pepperman has admitted to you that he does not have a medical license.
But see, this is my point, and I think that's kind of, I mean, I guess Hartsky was a little bit more forward-thinking than I thought he was when he made his decision, because he said there's no bright line, right? And education is one of the factors, and he's not a medical doctor per se in treating patients, but he's what is a fellow of the Royal College of Pathologists? What does that mean? Out of London.
I can't answer, I know he's not a pathologist. I mean, there's been no suggestion he's a pathologist here.
But I mean, is that a credential or not?
We don't know if you have to be a doctor, for instance, to get in there, and obviously we know that he doesn't have to be a doctor to get in because he's not a doctor.
I don't know if that's true or not.
I don't think it is. I mean, he's a forensic pathologist.
Well, see, here's the thing, there's a lot of speculation going on here as far as his credentials are concerned. And I don't know, but I do, in a general sense, typically, when it comes to London, England, they have a fairly high standard when it comes to the practice of medicine, right? They do. And I don't think anybody would disagree with that. And he's a fellow with the Royal College of Pathologists. What is that? I mean, what do pathologists do? And see, here's my point, and I get it, and he's not a licensed medical doctor, but if he's a fellow with, what is that? And here's kind of my point. And I'm not saying that he necessarily is qualified to testify at this point, but just as important too, yes, he doesn't treat patients, I get that, and he's not practicing medicine, he's not licensed in that regard. If he was being offered up as an orthopedic spine surgeon, that might be problematic, but we're talking about causes and effects of disease and injury, pathology, right? And that's something they kind of do, I think. What is it, med-dr? I don't know. I do know this, that his school, and I don't mind saying this because, and I think if I was a betting man, that if his school is on the approved list for the California licensing, the probability he's on most states, if not all states, you know. And I realize he'd have to come to America and take a test. I mean, I understand how this process works. But there's a lot of unknowns that I don't know right now.
Yes, John, I think that's fair, and I would just point out, obviously, it's plaintiff's burden to put this before the court, and they have not done so. And I do think that we have...
It's your burden. No, this is what's important. It's your burden if you file a motion limiting, right? Plaintiff, in this case, did not take a trial deposition. Trial depositions are different than discovery depositions, and they are. Hypothetically, if he wasn't testifying and he had to lay the foundation, I would expect that to be in a trial deposition. It's not a trial deposition, it's a discovery deposition. And I get it, I understand where you're going, I understand there are some issues, right? And hypothetically, I guess it's not hypothetical, I guess he was excluded from in another jurisdiction. What was he opining on? What type of, was it a orthopedic? I mean, I don't know. And that's kind of where I'm going here. But, and for example, to become a fellow for the Royal College of Pathologists in London, England, UK, what do you have to do to become a fellow? You know, I just kind of know this. I know a little bit about medicine and fellows. That's typically a higher level, right?
Your Honor, we're happy to get back to the court on that. I mean, I don't think that it changes the analysis under Hallmark because he still is not a licensed medical doctor, has never, ever diagnosed a patient ever, and he is.
But what did Hardesty say? There's no bright line there.
Well, he doesn't meet,
A nurse, I mean, he said, he used an example of a nurse potentially in another jurisdiction. But see, here's my point. And I guess, I mean, I realize this is a general definition of what pathologists do, but I don't mind saying I did mid-mount defense work. And typically they treat, they deal, no, not treat, they deal with the causes and effects of disease and injury, right? That's kind of what pathology is all about. I'm not saying that he can do it in this case, but I think it would be a lot easier for me to make a decision if we would have drilled down on all of his qualifications, because it's right here on his letter. And I understand it's not your fault. You didn't take the deposition. You're relying upon it. I understand what you're saying. You said, look, Judge, they don't meet the qualifications requirement. But and here's my point. Not every country is on the same wavelength as America when it comes to medical care. And for example, we have 2 schools of medicine. We have the osteopaths, we have the medical doctors. I kind of get that. But my point is this, he's a fellow with the Royal College of Pathologists. That just jumped out at me when I was looking at the gentleman's credentials, and I was thinking about it. And we do know, and like, I don't remember any significant inquiry in this case is what a MDDR is, right? I just took a general look. This is what I got, and I could be completely wrong on this, but it's at a level higher than a PhD, right? Number one. And number two, they say that the individuals that typically reach that level of study don't get there until they're 40 years old or so. So I don't know though, if that's true. I'm not taking that as testimony. I was trying to get ready for as I was going through the credentials, because you're asking me to look at it from a qualifications perspective. I don't know what this gentleman's total credentials are.
That's fair, Your Honor. We do have the published case of Adams that explains that this is directly from Dr. Freeman himself, that the med.br in Sweden is actually like a PhD. And I actually have a transcript from that evidentiary hearing.
Right.
And he explains to the judge, and he actually says that it's akin to a PhD. And from his testimony, I'm not even sure that that's on the pathway for a doctor in Sweden. It seems to me that he's suggesting it's a research degree.
And see, you're right.
Yeah.
But I don't know.
So how can we get you the information that you need to see on this qualification?
I think this is, right now, we're beyond discovery, getting information. I think, in a general sense, Mr. Pepperman is going to have to lay the foundation, and you can attack his foundation at the time of trial, and I make a determination then as to whether or not he meets the assistance requirement under Hallmark, right? Whether he meets the qualifications requirement under Hallmark. Because I do have a pretty big question regarding the Royal College of Pathologists, right? And, I don't know this, I don't know how do they segment that out? Because normally, fellows in pathology in the United States, I would think would be medical doctors, right? Or DOs.
Yeah,
That's what I would think.
and I can trust me, I'm gonna go look at this Royal, the pathologist, obviously, he's not a pathologist, he is not a medical doctor, so I don't believe that that's the case, that he has.
But tell me this, what do fellows, what is the training for fellows for the Royal College of Pathologists in the UK? What is that?
London.
I understand. Right. What type of training do they go through? Is there a certification?
So,
If any.
yeah, it's a professional, according to Wikipedia, so I don't really like to say that on the record. I don't.
No.
Because I just,
Judicial
go
notice,
there.
Your Honor, judicial notice of Wikipedia.
yeah, it's a professional membership organization. You maintain the standards and reputation of British pathology.
Okay, that's kind of for example, I don't mind telling you this, I have an older brother who's a fellow for the American Board of Plastic Surgery, right? And he had to go through significant training to become a fellow with that organization. Do they have fellows? I don't know.
I think board certification here in the United States, which I'm pretty familiar with, is quite different from a membership organization where they're paying their due.
And you might be right.
Yeah.
But I can't say.
Doesn't appear to be a doctor's group, let's just say. It does have fellowship examinations. This is 11,000 members, work in hospital, laboratories, universities, and industries worldwide.
So they're not even doctors, all of them. We have technicians and whatnot.
Oh, yeah, these terrible fellows. They're not a licensed medical doctor. They have no knowledge, experience, expertise. They can't add anything to this case. I mean,
But here's my point, and I'm not saying you're right or wrong. I'm just saying I have to make a decision, and do I know the answer to my question, right? That's all I'm saying.
And I understand that, Your Honor. I mean, I think, based off of him admittedly.
And I mean, but we can even go further, because
Yeah.
I'm looking at this, I mean, you have a transcript, but I'm looking at you, I mean, I don't know this. But there's and you know what, I don't mind saying this, I mean, some of these, when it comes to board certifications, you have like typically when you talk about fellows, they're typically supported by the different associations, like the Board of American, the Fellows for the American Society of Plastic Surgeons. They have their own fellowship. And I know this, you have to go through different standards, you have to be pass board certification, stuff like that to be accepted. Just on the flip side, you have people that make up their own boards. I mean, I get that. I know what's going on. This is my first rodeo when it comes to those types of issues. And for what I know, I'm looking here and all these organizations, they can be made up. I don't know, right? But all I have is a deposition that went into some detail, but I don't think it thoroughly explored all his experience and qualifications. Yes, I agree, he's not a medical doctor, but it appears to me what he's performing potentially here would be somewhat akin to what a member of the Royal College of Pathologists might do, potentially cause and effect of disease and injury. I don't know.
So Your Honor, I think that, what you just described there, cause and effect, would go to the general causation, and that's the epidemiology, and I do think that he has some qualifications for epidemiology, and that's not what we're challenging here. So we're challenging just the medical causation, his ability to make a medical diagnosis, specific causation, those types of things.
And here's my next question for you. Since we don't know the answer, do you think maybe we should find out the answer from him? Prior to, you know what I'm talking about?
I do think that we should, for an evidentiary hearing or whatnot, I don't think
We're
that.
not doing evidentiary, that's not how that works, we're not doing any, Mr. Parker, we're not doing any evidentiary. It's too late for that, I just want to tell everybody this.
That's fine, I think you've been given enough, Your Honor, to make a decision without one.
No, but no, I'm not, no, this is how this works. It's up to Mr. Pepperman to lay the appropriate foundation at the time of trial, and if it's insufficient, I strike him. You get a chance to cross-examine him. We voir dire him based upon qualifications outside the jury.
That's right.
Isn't that how that's done?
All day long.
Right?
And so, Your Honor, is the decision
I
on,
can tell you what it is, denied
Yeah.
without prejudice. Right, meaning you can voir dire him outside the presence of the jury, and you can do your research, find out what you can find out, I guess, because discovery's closed, notwithstanding that, before he opines on causation, right? You get a chance to find out and test his credentials and qualifications.
and Your Honor, are plaintiffs prevented from raising or mentioning these issues, his causation opinions to the jury before we get to that point? I guess that would be my major concern here.
Okay. I don't know.
Can we have this one deferred until we get to that point?
No, I can't defer these decisions forever, right? And I mean, and see, here's my point, you're asking for another question regarding what can be said in opening statements.
Well, yeah,
Right?
well,
It would be at our risk, Your Honor.
Well, I understand that, there is a risk to that, there's no question about it. But my point is this, one thing I know for sure, at this stage of the proceeding, is this, he's not a licensed medical doctor. I got that.
That's
I
correct.
understand that. So, secondly though, and this is what's a little bit unique about this case, we're talking about, pathogens, I guess, things like, what is it again?
hydrazine,
Hydrazine,
toxic
right?
agent.
Toxic agents, right? And I don't know the answer to this, but he does have a lot of qualifications. I do know this, that Justice Harshfield, I guess, thought outside the box, right? I mean, he did. He said, look, because I thought he was going to give, I don't mind saying, I thought he was going to give a bright line rule. And he said, no.
The hallmark is he has to be limited to the scope of his expertise, and while he has qualifications, those are all in a different area.
But we don't know this. You know, maybe if you had taken the deposition, we would know that. But you didn't, right?
I do think that there's that information before the court, but I understand the court's ruling.
Yeah. I will say, it's denied without prejudice. I don't think we have a fully developed record. That's all I'm saying.
Thank you.
All right. What's the next issue? How are we doing?
Number 19, Your Honor.
Where we at? 10 minutes?
Yes.
Okay, 10 minutes. Number 19? Which one is that?
Your Honor, I'm sorry. UNFI's motion eliminating number 19 is another expert motion to exclude Dr. Hudson.
Okay, let me find it. Let's take a break.
All right. Part 16 is now returning to session.
All right, I guess we can continue on. I guess we left off at motion number 19, right?
Yes, sir.
All right. And that's UNFW's motion and limiting the exclude testimony from William R. Hudson, MD.
Indeed. Your Honor, Jim Neale on behalf of the UNFI. Dr. Hudson is a medical doctor at West Virginia University. He's a gastroenterologist and hepatologist. There is not a qualifications issue here, so we can skip that part of the analysis. But there is, Your Honor, under 50.275 and under Hallmark's assistance prong, a question that UNFI wants the court to rule on. We don't think that Dr. Hudson's opinion as to Mr. Belsky and Mr. Haley is admissible because we don't think it would assist the trier of fact. There is overlap here between the motion you just heard on Dr. Freeman and the motion you are now hearing on Dr. Hudson. So I'll try to expedite this portion of the discussion, but it has to do with the variables about exposure of which Dr. Hudson remains unaware. And I think these are akin, Your Honor, to the variables that the biomechanic in Hallmark was unaware of when he attempted to take the stand and testify. Things like the speed of the vehicles, the angle at which they struck each other, the amount of time that they stayed in contact, etc. And I want to be clear and try to reiterate one thing that Mr. Hoffman said, which is the burden here is not on the plaintiffs to demonstrate that each bottle of real water contained X parts per billion of hydrazine, and we're not attacking Dr. Hudson or Dr. Freeman for not knowing those variables. But even under the plaintiff's analysis, Your Honor, there does need to be a showing, or at least some analysis, that the exposure in question is sufficient to cause the injury in question. And there's a point at which the unknown variables accumulate and render any such opinion entirely speculative and conjecture. And that's what we've got here. I'll run through them quickly. But Dr. Hudson was very clear that he wasn't aware of the concentration of hydrazine in any bottle. You've heard some of this before. He wasn't aware of the amount the plaintiffs consumed. And again, Your Honor, this motion concerns only his opinions as to Mr. Haley and Mr. Belsky. He wasn't aware of hydrazine's latency period. The latency period, Your Honor, the court may know, forgive me.
But make a record.
Latency period is the amount of time between which a substance can be ingested and injury is likely to manifest itself. And the reason it's important in a causal analysis is because if one ingests a product outside the suspected agent's latency period, then it makes it extremely likely that that product is not the cause of the subsequent injuries. Dr. Hudson was quick to say that he has no idea if the amount of hydrazine in any retail real water bottle was hepatotoxic, that is, could harm the liver, or whether even the highest value recorded on the Eurofins analysis, that 300 parts per billion, would be enough to cause a liver injury. I do want to remind the court that 300 parts per billion is 1/70th of what the plaintiff's toxicologist said might cause a liver injury in some people. And so again, as with the latency period, I think the lack of knowledge or analysis about the hepatotoxic level of the substance in question takes whatever might be expressed as an opinion under one set of circumstances and converts it into conjecture or speculation here. So when we put that together, Your Honor, what we're left with is that Dr. Hudson, by his own admission, doesn't know how much you need to drink or when you need to drink it to be vulnerable to an injury. The good news is he doesn't care. It's just not of any concern to him because he says, kind of mimicking the Holcomb any exposure analysis that the Nevada Supreme Court's rejected, that any exposure is good enough. And I don't think that's the case, Your Honor. It's certainly not the case under Holcomb. And that's why those missing variables are as critical here as they were to the stricken biomechanic in Hallmark. And just to illustrate one more aspect of it, we have, as Mr. Hoffman pointed out, we have the dose dependency calculus that is necessary to determine whether somebody's ingestion of real water materially increases their risk of hepatitis. That data exists, that data was provided, that data is from the CDC and the FDA, but not knowing any of the variables that, or not being concerned with, I guess I should say, any of the variables about quantities consumed or latency periods within which that might be consumed or otherwise, we turn a blind eye to that known set, to that methodology, to that demonstrated science, and we instead rely on a more simple, it is so because I say it is so. You drank the water and you subsequently had hepatitis, ergo, the hepatitis was caused by the product. And in case Your Honor is concerned that I'm exaggerating, John, could you pull up, please, Dr. Hudson's deposition transcript at page 135 and 136. We've talked a lot about causation, and I think we've arrived at a general consensus that there's general and specific, and that the first step or the preliminary step is general. Is there an agent out there at a sufficient dose to cause an injury? And instead of determining that or concerning himself with that, Dr. Hudson did something very different. He didn't say, here's a hepatotoxic dose from an animal study or from a human study or from a case study. He didn't say that this is a hepatic dose consumed within the latency period. Instead, he said, if we have it, John, I don't know if it's available.
Chris.
Thank you. Here's what he said at page 135 of his deposition transcript, beginning at line 24 and going on to the next page through line 9.
Hold on, I want to follow you. 135,
Yes, sir, 135, line 24.
okay. I'm with you.
Through 136, line 9. And this specifically concerned Mr. Haley, but the methodology is equally applicable for both Mr. Haley and Mr. Belsky. I asked Dr. Hudson, and of course he didn't know the answer to this, what the specific bottles Mr. Haley drank of real water in terms of quantity or concentrations or timing. And he agreed, but said there's an even more fundamental point, which is, I've got no idea what it takes to cause this injury that I'm about to diagnose. So even if I had the number of bottles Mr. Haley drank and knew when he drank them and knew how much hydrazine they contained, you could give me every missing variable to the equation, and I still couldn't tell you whether that substance was capable of causing an injury, because I don't know if that's hepatotoxic. Well then, doctor, how in the world can you diagnose it if you don't know any of these variables? And the answer is, well, he got sick. He got sick after he says he drank it, therefore he must have had enough. And I think the court will recognize that as exactly what's forbidden and exactly what is not under the hallmark assistance factor based on rational facts, but is instead based on speculation and conjecture. And it's especially true, Your Honor, when one considers that Dr. Hudson admits at page 78 of the same transcript, John, lines 19 through 23, that's not the one I'm looking for, John. I may have given you the wrong. Page 78, did I say it?
Wait,
Yeah.
wait, I'm gonna follow you.
Yes, sir. Thank you. I appreciate that.
Page 76 instead, is that it?
I was mistaken, Your Honor. It's page 78.
I'm with you.
Page 78, line 19. If I were to ask you, and we don't have time to do it, but if I were to ask you to itemize all the things that could cause DILI, and the court will perhaps recall that that's drug-induced liver injury, what's your estimate of the number of things that would be on that list? Hundreds and hundreds and hundreds. And as Dr. Hudson says in his report, you have to rule out, this is a diagnosis of exclusion. You have to rule out all of them. And that's particularly true if you can't rule in, as he's unable to do, the one that is the target analyte of concern, hydrazine. So he can't say that there's enough hydrazine to do the job. And he can't say that I've ruled out the other 299 things. I'll show the court one example of that in a moment. And so what we're left with is just the simple A occurred before B, so B must have been caused by A. It's akin to Dr. Freeman saying, I don't know how far you have to fall to die, but if I find you dead on the ground, you fell far enough. I think a real causation analysis goes a little farther into the cause of death than that. And I think that this would be equally speculative for Dr. Hudson. So if we look at what Dr. Hudson did or didn't do to rule out other causes, let me just illustrate with one with Mr. Belsky. This is acetaminophen. I'm sorry, I'm mistaken. This is augmentin, an antibiotic. John, if you could go please to page 105. Mr. Belsky suffered sinus infections chronically. He's had several surgeries. It sounds like a miserable condition with which to live. Every time he flies, he's in pain and discomfort. And to alleviate that, he frequently takes augmentin, which is, of course, a generally prescribed antibiotic. And on page 105 at 5 to 7, Dr. Hudson notes that John, I've messed this up. I apologize. I've got the wrong site.
No, take it, sir, take your time.
Thank you. I don't know if you can find it, John, but there's a site where, a spot in the deposition where Dr. Hudson says 45% of DILI cases, drug-induced liver injury, are caused by antibiotics. The liver obviously has a tough time filtering out the toxins that are in
Is that
there.
105?
Well, I thought it was 105, Judge. I'm going to have to, let me do this.
It does talk about drug-induced liver injury.
Well, thank you for the lifeline. It's
Question
charitable,
7,
but
Answer 8, that's not the one? Answer, I'm sorry, line 9.
John, let's try it. Page 151, please. 150. How many tries do I get? 150.
There we go.
Line 3 through 7, Your Honor. And now you will see that Dr. Hudson says 45% of all drug-induced liver injury cases come from antibiotic use. Not abuse, not overdoses, not irresponsible patients who don't follow their script, just from regularly taking amoxicillin, Augmentin, etc. It is the number one antibiotic. If we go to the page before that, John, I've got it as 149. Let's see if I can redeem myself here. Line 24 to page 152. Excuse me, page 150, line 2. What is the number one antibiotic? It's, lo and behold, Augmentin, the same prescription that Mr. Belsky took for many years to combat his chronic sinusitis. When Dr. Hudson, John, page 151, line 3, is diagnosing DILI, the first potential agent of concern to him, number one on his list, or sorry, I shouldn't exaggerate, near the top of his list, is Augmentin. Page 152, John, line 24 to page 153. Mr. Belsky was taking Augmentin close enough in time to his liver injury for it to be the cause. And John, page 155, lines 7 through 8. The question to this, you can leave it right there, John, but the question to this that prompted this answer was, did he take enough Augmentin to cause a liver injury? Dr. Hudson says he technically, he could take enough. That could be enough to cause a liver injury. So Judge, we've got hundreds and hundreds and hundreds of potential causes, in Dr. Hudson's own words. We didn't get very far down the list. We're at number one before we found one he didn't eliminate. And it's not one that we're making up. It's not the pixie dust that Mr. Kemp has sometimes referred to, or the unknown pathogen. It's the top of the list. He took enough. He took it at the right time. He'd been taking it for years. 45% of the people who suffer this injury suffer it for this reason, and I didn't rule it out. That's not a differential diagnosis, and that's not a admissible or helpful opinion under Hallmark, especially when, Judge, the cause that you're fingering, you know nothing about. If we compare Augmentin on the one hand and hydrazine on the other, we have an established track record with Augmentin and none with hydrazine. We have a known quantity with Augmentin and none with hydrazine. We have a documented intake and consumption history with Augmentin and none with hydrazine. We have a demonstrated consumption during the latency period with Augmentin, but not with hydrazine. And we know exactly what the dose was because it's a regulated, prescribed substance, unlike hydrazine. So we have to figure out why Dr. Hudson then ignores all of that solid scientific and medical data, turns a blind eye into it, and instead latches on to hydrazine.
Could it be because he didn't have a problem with the Augmentin?
Well, I don't think that's the case at all, Your Honor. I think his liver is the problem with the Augmentin.
But I mean, here's kind of my point, and understand this. I'm not saying whether he's right or wrong or who I should believe, but at the end of the day, many of these issues are question of facts for the jury. And of course, you can offer up independent alternative causation theory as it pertains to this plaintiff. I mean,
Yes.
clearly, I can kind of see that road, but I'm just looking, and this is, I think he pointed to page 155. And the question was, this is at line 4. Did he take enough augmentin to cause a liver injury? Mr. Parker objected. The witness answered, he could take enough. That could be enough to cause liver injury, but he never had a liver injury from the time he had been taking it.
Yes, sir.
You see where I'm going on that?
Yes, sir.
I mean, it's like.
Can I respond to it?
Yeah, you can.
All right, great. I'm not asking you to raise one arm and hold the other one down like a referee at the end of a boxing match. I understand these are contested issues of fact. Let me get to the methodology, because the facts are not what we're asking the court to rule on. Hallmark doesn't say you exclude an expert because you don't like his conclusion. Hallmark says you exclude an expert because of the methodology he uses to get there. And that's what I want to point out. When you have dueling plausible theories like this, you have to attack them both with the same amount of rigor and skepticism and methodology. And here's what Dr. Hudson did instead. Let me go, please, to the Hudson report at page 7, John. Can you highlight, please, number 2 at the bottom there? This is his bottom line opinion as to Mr. Belsky.
Right.
And again, we're not asking the court to weigh in on whether the doctor's right or wrong. That's not my job or the court's job. That's for the jury, to the extent that evidence is admissible for them to decide. But here's how he got there. John, 119. Let me before we go there. What you'll notice here, Your Honor, and Mr. Belsky's unique in this regard. He is the only one of the 7 plaintiffs in the Gallagher case to have consumed retail water and 5-gallon water, and be making a claim both against Real Water, the manufacturer and direct distributor of the 5-gallon product, and against UNFW, a distributor of the retail product. You're with me there, Your Honor?
No, I'm with you.
Okay, so he's got 2 separate claims, 2 separate products, 2 separate sets of defendants that he is saying caused his injury. And I represent one of them. And so naturally, I'm very interested in whether my client's product caused this injury, or substantially contributed to this injury, or under the Holcomb test, to the extent that applies, had an exposure that was substantial enough in regularity, proximity, and frequency to plausibly cause the injury. And when I asked Dr. Hudson to parse that out, here's the methodology that he gets to arrive at his opinion. And spoiler alert, Dr. Hudson says, well, both retail water and 5-gallon water caused this injury, and I don't care how much of one versus the other he had. I don't care when he had one versus the other. I don't care what the relative concentrations of hydrazine might have been in one versus the other. I believe they're both responsible. But if we press Dr. Holcomb and, Dr. Hudson, and ask him how he arrives at that, page 119, please, John. Line 18 through 21.
Line 119.
111, yes, you're right, 119, line 18. So, I'm very, Dr. Hudson, your report doesn't say that my client's product caused Mr. Belsky's injury. Let's talk about that. I need you to tell me how you would go about parsing out one from the other. And Dr. Hudson's answer is, I'm not trying to assign causation to one versus the other. It's not possible. It simply can't be done. Nobody can parse it out. Page 119, 6, John, to 21. Nobody in the world can tell you which one caused the damage. And I think this is the key for Dr. Hudson, and this is perhaps the death knell and what I believe is a fatal admission to his opinion, you have to assume that it's both. This is an assumption. There's not a single particularized fact that went into Dr. Hudson's opinion about whether retail water that Mr. Belsky drank at an unknown time in an unknown quantity with an unknown concentration of hydrazine at the same time he was taking his augmentin could possibly cause his injury, never mind actually did. That's exactly what Hallmark prohibits, is assumptions and speculation rather than opinions that are built on particularized fact. To the court's earlier question, the opinion doesn't have to be right, but it has to be built on some particularized facts. And here's Dr. Hudson saying, I choose instead to build with a foundation of assumptions. And because he says that, the methodology is not reliable, and the opinion's not assistive under Hallmark.
So I just want to make sure the record's clear. He was drinking both 5-gallon jugs and retail bottles?
Your Honor, I think the evidence is going to...
Absolutely clear, Your Honor.
I'm just asking questions.
So here's what the evidence will show. John, can you please pull up the video clip for Mr. Belsky, page 94, line 10 through page 95, line 6. I'm not sure the sworn testimony is as clear as Mr. Parker would like for it to be. I think there's definitely a sequence to the consumption. And the sequence is key, Your Honor, and the sequence is another thing that Dr. Hudson ignores. Go ahead and hit play if you can, John, for me. This is
And then you provided us and then when you got the home delivery, you stopped drinking, stopped buying the retail product. Correct. Did you ever, you must have occasionally bought bottled water after that.
Well, as I mentioned earlier, I occasionally bought distilled water for use in small home appliances, like a tea kettle, that type of thing. Yeah, sure. There would be times if I went to a gas station and I was thirsty, I might buy a Dasani or something like that. But
no retail real water purchases after that.
not that I can recall.
Do you recall the last time you consumed retail real water?
I couldn't tell you an exact time. It would be in that time frame of some trip to Whole Foods just prior to the first delivery of the 5-gallon jug. And into that post-delivery period where there might have been some bottles still around the house.
all right, Your Honor. So Mr. Belsky, understandably, can't say exactly when he last purchased or consumed retail real water. He was hospitalized on May 24th. I shouldn't say that. He went to the emergency room on May 24th, 2018. Two years before the outbreak that the CDC and Southern Nevada Health identified. And so these dates are a little bit important, but what Mr. Belsky is sure of is that when he started home delivery, he stopped buying retail water. And there may have been a stray bottle or two around the house. But he said, I had all the water in the world I could drink at home from that 5-gallon machine. Why in the world would I spend money at Whole Foods or anywhere else on bottled water after that? Now, so all we need to do is figure out when Real Water started delivering 5-gallon jugs to Mr. Belsky's home. John, can you pull up, please, Belsky R0267? And we know from a check that he produced, Your Honor, that's dated 4/11/18, that he was paying Real Water for home delivery as of that date. That's 6 weeks before his hospitalization. And at the time of his deposition, that's all we had. So we assumed that he was buying retail Real Water sometime not terribly distant from the day he went to the emergency room. But that's proven to be terribly incorrect. John, the delivery records, please, at Real Water 220-648. this is a little tough to see, Your Honor, but this is a service list for a route delivery. And John, can you highlight, before you pull up the date, can you highlight Mr. Belsky's name? His is the first in the second group, the top one in the second group. Down a little further, I'm sorry. Bottom half of the page, it says Richard Beliski, 554 Bracken. And one of the reasons this wasn't immediately apparent was because Real Water had his name misspelled in the records, but that's Mr. Belsky's address, and we know that he's on a route delivery, and if we could figure out when this route delivery was, we'd know that delivery date. So John, if you can pull up, please. It's difficult to see.
So what's the quantity being delivered?
Yeah, I forget exactly what Mr. Belsky said in terms of what he was paying. I think he had talked Real Water down to $9 or $10 a jug. And so that $90 check in April was for 10 jugs. And this March 7th, 2018 delivery, John, now that we have the date, thank you.
Was that monthly delivery or?
No, Your Honor, well, it was more frequent than that. We'll see that on some other earlier documents in just a minute. But it says frequency too. I don't know this for sure. I believe that's going to become apparent that that's every 2 weeks. All right, and then, so now we're more than 2 months before his hospitalization, when he, according to his own sworn testimony, stops buying retail water.
And out of curiosity, how many people were living in his house?
He lived there, Your Honor. He had a live-in significant other, and he had a tenant roommate on and off.
And the only reason I asked that question, it seems like to me potentially he would be at a high level of water consumption if he's getting, how much again? You said frequency every
2 weeks.
2 weeks, and how many 5-gallon jugs would that be?
Well, he was getting several at a time. And I think Mr. Belsky would admit that he was drinking a significant, he's a health aficionado. I think he watches very carefully what he eats and drinks. I think he would classify himself as a well-hydrated, frequent drinker of large quantities of 5-gallon real water. So we're now 2.5 months before his hospitalization. But the beat goes on, and these are later disclosed documents. John Belsky 341, please. This is another check that Mr. Belsky is writing to Real Water. This one on February 12th, 2018 for $36. And if my recollection is correct, Mr. Parker will correct me if I'm not. My recollection is correct, that would represent 4 5-gallon jugs for that delivery.
So that would be 20 gallons.
20 gallons of water. And I think more importantly,
That's a lot of water.
it's a lot of water. It's a lot of 5-gallon water. And it's getting to be a longer and longer time before his illness. We're now in February. This is now 100 days prior to his hospitalization. But we're not done yet. Belsky 340. These are all produced after his deposition. But again, they demonstrate a 5-gallon. John, let's spend a little time with this. Start at the bottom where it says next deliveries on the right-hand side. That's perfect. So a couple things here, Your Honor. This is a statement dated January 31st, 2018. This is 120 days before his hospitalization. That means he stopped buying retail real water prior to this. He has a balance at this point of already $70. The math doesn't work out perfectly, but I don't know how to account for the 30 cents difference, but I think that represents 8 jugs of water. What I point out to the court there are the next deliveries. He's getting the water delivered to his home every 2 weeks.
And what quantity again? Right now, just to make sure.
Well,
What does it say?
it's not set, Your Honor. I think the way I understand the system worked was that I, as a subscriber, would leave a number of empty jugs on my front porch, and Real Water would replace those empty jugs with full ones. So 1 week it could be 2, 1 week it could be 5. It wasn't necessarily locked into a certain amount. The best way to tell the volume that I can gather is by looking at the money's paid. But by the end of January 2018, well, let me go, because I have a statement date, January 31st, he's already consumed at least 8 my math is bad, 8 5-gallon jugs. And we can, and I'll point out again, we're 120 days before the hospitalization. Last document, please, John, Real Water 03543. This is, Your Honor, a service agreement. It's not signed by Mr. Belsky. It does have his name and address on it. I can't represent to the court exactly what it is, but it certainly appears to be a trial subscription that enabled a delivery, if not the first delivery. And the only thing I'll point out to the court is that it indicates that Mr. Belsky at his home address is getting 2 free bottles. And it's dated at the bottom by Real Water, November 13th, 2017. Judge, we are now 6.5 months before Mr. Belsky's hospitalization on May 24th. And if there's not a delivery before this, we know that he stopped buying retail Real Water at this point. It was either here or earlier. Now, what does that mean for causation? Can we go to the Freeman deposition, please, at page 38, line 17. Dr. Freeman is the fellow from the Royal College of Pathology that you heard about in the last motion. And here's what the pathologist says, or the
We'll find out.
med.dr says.
We'll find out. That's all I can say.
About latency period.
We can find out. I don't know.
What is the latency period? Dr. Freeman, it's days to weeks. I wouldn't say multiple weeks. That's not what I've seen in the data. So when you were doing your analysis of each of these individuals, did the time at which they last drank Real Water factor in to your analysis? After an objection to form, the witness says, as long as it wasn't more than weeks prior, no. And Ms. Anderson asks, so if it was within the days to not too many weeks, it wasn't a factor. But if it would have been longer than that, it would have been a factor. Is that correct? It is. And the witness goes on, if someone says I drank Real Water last year, and this year I have symptoms and start throwing up, it would be temporally implausible that the two things would be associated. That's exactly what we've got with Mr. Belsky's sworn testimony. May 24th, 2018 hospitalization, and 5-gallon deliveries 6+ months prior in 2017, the prior calendar year. Now that's an analysis that at least Dr. Freeman went through. Here's Dr. Hudson saying, I don't even know the latency period. I'm not even going to bother with it. I don't care when they drink it. And what he says about the latency period puts Mr. Belsky outside of it. Hudson deposition, please, John, at page 120, line 15. To 21, if you can call that out. What's the latency period for ingesting? We were speaking specifically of hydrazine at this point, Your Honor. And Dr. Hudson says nobody knows exactly what the latency period is. It's all been hypothesized, another unknown variable. Now, if you look at drug-induced liver injuries in general.
And you know, these are just thoughts I have, and I don't know how relevant this is or not, but it appears to be a lot of unknowns as it relates to hydrazine and human consumption. Could it be because it was anticipated that in a general sense humans wouldn't be consuming hydrazine?
Well, I don't think that's necessarily the case, Sean. I don't know that any.
I agree with that, John. But I'm sure Mr. Neale and I.
But the only reason I was just looking at it from this perspective, and I learn more as we go each day. It's something that's not naturally occurring, right? And for example, when you deal with asbestos. I'm just asking a question.
I'm certainly not laughing at the court, I'm laughing at Mr. Rasmussen, who's
Yeah, but
misled the court, I'm afraid.
Well,
Unintentionally, sure.
I love the dissension in the ranks.
No, but anyway, I'm just kind of looking at it like with asbestos, we have naturally occurring asbestos here in the desert. You go out desert in Las Vegas,
Yeah.
you go out to Boulder City and things like that. And I can understand how there might be difficulty with the occurrence or I get that. But and I'm just asking questions, and it's a temporal observation. I might be wrong, but I'm just asking, I don't know, right? I know you're gonna have something to say on this issue.
Let's not invite that.
I agree with Neale on that one.
Yeah, but I'm gonna listen to Mr. Rasmussen.
No.
But that's kind of, I was thinking about it from this perspective. If it's something that's not naturally occurring, typically it's not part of, and this, I'm saying this in a clumsy manner, but it wouldn't be associated with the food chain. Maybe that's the reason why they didn't test it.
It's not a known data set.
Okay, that's the technical way
I'll
of saying it.
I'll accept that. I would suggest, Your Honor, John, can you pull up,
There you go, known data set.
can you pull up the Western Environmental Test Report? I don't think that's in this motion.
And that's okay, but that shows my observation. I might have
let
to
me-
be proper.
John, don't do that. Let me do it a different way. It's not a known data set, Your Honor. I think that's true for myriad
Oh, I get it.
substances, natural and otherwise.
Right.
And Mr. Rasmussen's just dead wrong. Hydrazine N2H4 does occur naturally, but that's a dispute for a different day.
That might be a dispute for the experts, right?
Uh,
Maybe, I don't know.
Here's why, though, Judge, that doesn't bail out Dr. Hudson. It's because of what he says next. Can you go back to that, John? Dr. Hudson says,
And what page? What page?
same one, Your Honor, we haven't moved. We are still on page 120.
Okay, I'm with
Line 15 through 21. Dr. Hudson says, I don't know hydrazine. And he may not know benzene or arsenic or sodium chloride or anything else. I don't think he has to, because what he can say is categorically, when you look at drug-induced liver injuries in general, the latency period lies somewhere between 2 and 20 weeks. That's all substances. That's all toxins. That's 20 weeks is the outer limit that Dr. Hudson himself would assign to any drug-induced liver injury, whether it's caused by hydrazine or augmentin or anything in between. So we have an expert here saying 20 weeks is the outside limit for drug-induced liver injury. Beyond that, A can't cause B. And we've got a witness saying, I stopped buying real water about 40 weeks, if my math is even close, before my hospitalization. That's a pretty significant difference. And again, I'm not asking the court to say Hudson's wrong, Dara's right. I'm gonna ask the jury to do that later. What I'm asking the court to do is say, Hudson didn't even analyze the latency period. Hudson has in his possession and knowledge facts that would have excluded this as a potential cause, the retail bottled water. Because by his own data, by his own factual basis, by his own statement under oath about the latency period for all DILI, all drug-induced liver injuries.
What about this statement he says right before that? He said, and this would be at line 13, and this was part of the response. He says the same water goes into the retail bottles, goes into the 5-gallon jugs, so they're both at fault. What do I do with that?
Well, that's not a causation opinion, Judge. The same water does, there's no question about it. There's common ingredients.
The same water goes in the retail and the 5-gallon jugs. What difference does it make? Because it was my understanding, he was being delivered, home delivery. It appears to be a fairly high amount of water.
Yes.
Before the hospitalization.
Yes.
In May of 2018, is that?
May of 2008, May 24th.
Okay.
Here's the tremendous difference it makes, Your Honor. It makes a difference because that only implicates one defendant. It doesn't implicate, in fact, it exculpates UNFW. Dr. Hudson says the latency period for Dilly is shorter than the gap between Mr. Belsky's consumption of real water, retail real water, excuse me.
I get it now. So what you're saying, look, Judge, UNFW is delivering retail bottles to Whole Foods, but they weren't involved in the transmission or transportation of the 5-gallon jugs.
You've got it.
I get it.
So he has one opinion that purports to implicate both defendants, but he professes the absolute inability to parse it out in a manner that assigns causation to both defendants. And so what he does instead, just to remind the court, 119, please, John. Page 119 of the Hudson deposition at page 6. Excuse me, line 6. He says it's impossible to do. Nobody in the world can tell you, so you have to assume. We've now got Dr. Hudson assuming causation, even though he's got a latency period shorter than the consumption gap, and even though he doesn't know any of the other variables regarding toxicity, concentration, quantity, etc. The motion doesn't say, to make it really clear, Your Honor, Dr. Hudson may be right about the 5-gallon product, but that's all the more reason that the opinion as to UNFW is not admissible. He later calls his opinion, page 117, John, line 24, to page 118, line 1, a supposition. Whether it was 5-gallon jugs or retail bottles, both is my supposition, because the water is the same and the concentrate's the same. Suppositions don't cut it. There has to be some analysis, especially when the doctor says he has the tools to do it, but for some reason doesn't. So, Judge, again, I'm almost done, the court's been patient. Hallmark requires the opinion to assist the jury. To assist the jury, the opinion's got to be the result of a reliable methodology. To be a reliable methodology, it's got to be based on, quote, particularized facts, and not assumptions or conjecture or supposition. And by his own admission, Dr. Hudson's opinion fails on as to UNFI's causation. By his own admission, Dr. Hudson's opinion fails there. And I'll put this, maybe a final point on it. The plaintiff's response in opposition focuses on Holcomb. And Holcomb is the mesothelioma case, Your Honor, where a relaxed standard of causation was adopted in that context when you had multiple defendants, because plaintiffs also often had difficulty differentiating between General Motors and Ford and other asbestos manufacturers.
Was this the Brick case?
Yes, sir.
Okay.
But even under that case, what the court required the plaintiff to do was to show a substantial exposure, and even more specifically, an exposure that had regularity and frequency and proximity to the illness. In other words, there has to be enough of the problem agent there to cause the injury, and it has to be close enough in time to have done that. I don't know that Holcomb applies. I don't think that any court's ever applied it outside of the mesothelioma context, but even if you do, all it does is lay bare the shortcomings of Dr. Hudson's opinion, because he can't talk about regularity. He can't talk about frequency. He can't talk about proximity. And he can't talk about toxicity. The only thing he's got, Your Honor, is B happened after A, so A must have caused B. And I'll page 136, John, lines 4 through 9. And again, this isn't me saying this. This is Dr. Hudson. I don't know what the concentration is that it takes to cause a liver injury. He's speaking of hydrazine. So the bottles may have had hydrazine in it, but we don't know what that lower limit is. There is an amount of hydrazine, Dr. Hudson says, in other words, Your Honor, that you and I can safely drink with no adverse effect. And he doesn't know what that number is. He doesn't know what that dose per kilogram is. He doesn't know what the frequency with which consumption need be to cross it. But the fact that he got a liver injury tells me whatever the threshold is, he crossed it. That is the definition of an inadmissible, unhelpful opinion that assumes causation. The fact of illness, Your Honor, never equals cause. We know that from Wilson versus Circus. Cause can't be assumed or can't be a supposition. Any exposure, which appears to be the only theory Dr. Hudson can embrace here, was squarely rejected by the Nevada Supreme Court in Hoffman. And assuming or supposing in the absence of all that information is not a reliable methodology under Hallmark. So it can't possibly be expressed to a reasonable degree of medical probability under Moriscato. There's simply no way in which this opinion is admissible. And that's why, Your Honor, as to UNFW, we moved the court to exclude the causation, the specific causation opinions. Dr. William Hudson. Questions, Your Honor?
No, not at this.
Thank you.
We have jointers, right?
We did, Your Honor, Scott Rasmussen on behalf of the since we did join, I don't have anything to add at this point.
Are you sure?
Other to say that sulfate is used in cancer treatment all the time. And so it is consumed every day in the United States for people who are going through cancer treatments. So to suggest that it isn't available for human consumption, yeah, I wouldn't put it on a dressing on my salad, but certainly it is something that is consumed for those sort of things.
All right.
Your Honor, we're water adjoined, but obviously Mr. Neale has made a distinction between the two defendants, so it's not really applicable.
I understand. Anyone else? I don't know what we're looking.
Tennessee joined for the same reasons expressed, except for, I think, counsel meant to say duration instead of regularity. Frequency and regularity are pretty much the same thing. So it's proximity, duration, and frequency.
Thank you, Mr. Kemp. All right, we've covered all the defense, right? Okay, we'll go to the defense.
You have control of the screen? Mr. Neale has been kind enough to admit that Dr. Hudson has the requisite experience, education, general qualifications to offer the opinions he's offered, Your Honor. So in terms of Hallmark, we won't spend a lot of time discussing his credentials. What I've just witnessed was Mr. Neale completely ignore the papers that they filed or the opposition that we filed and put before the court several documents that were not referenced in the briefing, attached to the briefing, but perhaps they were for theatrical effect, get us thinking about things that really weren't squarely addressed in the four corners of the briefing. But I want to start off with where Mr. Neale kind of left off. If you could, Chris, can you bring up our opposition? Mr. Neale was not at this deposition, I don't believe, and if he was, and I apologize, I don't believe you were, Mr. Neale.
Hudson?
No, not Hudson. You were there, you and I were both there.
Morgan?
That's right. So, Your Honor, this is our plaintiff's opposition to this motion, motion number 19. Chris, if you could go to page 12, please. And Your Honor asked this question, and, you know, you keep telling us, Your Honor, that you're learning this case, but for some reason I believe that you're feigning still learning, because I think you know a lot about this case already. Because your questions are too pointed to not know quite a bit about this case already. Maybe there's some more details and facts that you'll learn through the process, but I think you have a good handle on what this case is truly about. Chris, page 12 of our opposition. I don't know what page this is.
Page 12 is free.
Of our opposition, page 12. Of the book, yes. So, Your Honor, what you're looking at here at the bottom, you can highlight that deposition testimony starting at line roughly, start at 16. Then we'll go,
We're on page 12, right?
yes, Your Honor, of our opposition, the plaintiff's opposition to UNFW's MIL number 19. No. Chris, go up to 16, please. Line 16. Just go up a little bit more. There we go. So the deposition was taken of Mr. Belsky's mother, Maria. And Maria testified that when her son went into the hospital, in addition to having real water jugs, he still had real water retail bottles in the refrigerator. And so when I hear Mr. Neale get up and say there's no evidence that he had any retail bottles, it flies in the face of the testimony from Mr. Belsky's mother, Maria, who in fact drank some of her own and informed us during her deposition that members of their family got sick drinking the real water while Mr. Belsky was in a hospital being taken care of medically. And here it is right here in the opposition, Your Honor. It says, while in Las Vegas, Maria stayed at Rich's home and drank several retail bottles of real water that Rich had in the refrigerator. And she recalls, in addition to having real water jugs, there were other types of bottled water that you recall being at the house. No. Do you recall whether you drank from 5-gallon dispenser Rich had, or their smaller retail bottles at the house? I remember filling bottles with the water from the 5-gallon jug, but there were bottles in the refrigerator as well. So I would drink the bottles in the refrigerator, and when I was finished with those, I would fill them with the 5-gallon jug. You know, within days of going to the hospital, not months, not the year before, Mr. Belsky still had retail bottles, ready-to-drink bottles of real water in his refrigerator. So there is evidence that Mr. Belsky was still drinking water within the latency period that Dr. Hudson testified to during his deposition.
Now, I want to be clear.
Sure.
Because as I go through this and I listen to the evidence, when it comes to the retail bottles of real water, how were they sold at like Whole Foods and the stores? Were they like in 24 packs? Were they individual? I mean, I don't know.
You can buy them just like this, Your Honor.
I get that, but you can buy those in 24 packs.
You can. But we know that Haley bought them singularly. Mr. Belsky said he would buy, if he was at the gas station or wherever, he would buy retail bottles. And he had retail bottles in his
How were
home.
retail bottles purchased? Only individually, 24 packs?
There's a big display, Your Honor. I thought we showed it in one of the previous pictures, but they call them stacks. They stack them up and you can go and, I can't remember if it's 6.
It's like going into Walgreens and pick up.
Right, exactly.
Different quantities, Your Honor. So you could buy a single liter bottle, you could buy a gallon bottle, you could buy a 12-pack, 24-pack. Different stores stock different sizes.
Good enough, Your Honor?
Yes.
All right, perfect. So, Your Honor, to suggest, as Mr. Neale did, that there was no retail bottles being consumed by Mr. Belsky within days of going to hospital is simply incorrect. The evidence suggests otherwise. Now, Mr. Neale spent a tremendous amount of time talking about what Mr. Hudson, Dr. Hudson did or did not do. And I'd like to start off with his report, which is attached to the the opposition, Your Honor, is Exhibit 24. And the documents I'll be using are actually documents attached to the briefing as opposed to documents thrown up before the court that were not attached to the briefing. Could you go to Exhibit 24, please, Chris? And so, Your Honor, the first page of this document, after the title page, is the qualifications. We're not going to spend much time, other than, I think Mr. Neale has already indicated that he is a gastroenterologist, he's a hepatologist, he's the director of hepatology at West Virginia University Medical Center and Ruby Memorial Hospital, Morgantown. He's also a professor of medicine and surgery at West Virginia University School of Medicine. And in fact, Mr. Neale and I had the pleasure of participating in Dr. Hudson's deposition in Morgantown. If you could go to the...
Another foreign country, Your Honor.
Yes, I bet.
And so, Your Honor, the bottom of this first page, if you could scroll up, Chris, is a discussion regarding DILI or drug-induced liver injury. And if we go to the next page, the third paragraph discusses alternative causes of acute or chronic liver injury, which is his discussion of a differential diagnosis where he considered other possible or alternative causes, something that William speaks to, of course. And, Your Honor, if we go, Chris, go to the bottom page, please. And, Your Honor, I'm not going to spend as much time as Mr. Hoffman or Mr. Neale did going through each of these documents, since I would think the court had an opportunity to do so since they're attached to the brief. But here it says at the bottom that hydrazine was identified in concentrate samples in concentrations of 1.33, 1.44, and 1.75. And I bring this to the court's attention because Mr. Neale made a point of saying that anything above 1.5, based upon the toxicology in this case, would be harmful to human consumption. So we know at least one of the three concentrates tested by the FDA came back in excess of that.
I'm sorry.
Now, I'm sure Mr. Neale will come up and correct me as to parts per billion, and I look forward to it. But what we can discern from this document and from the Eurofins testing, Your Honor, is that every test, hydrazine-related test of real water, be it a bottle or a jug, or the concentrate, came back positive. Now, this Dr. Hudson considered turmeric in terms of Mr. Haley and kratom in terms of Mr. Belsky. And it was his opinion, after reviewing the medical records of all 7 plaintiffs, reviewing the FDA, SNHD, CDC documentation, reviewing depositions, reviewing the fact sheets, having his own personal interviews with each of the plaintiffs, that their liver injury was secondary to their consumption of real water. And he does that on the final page, or pages of his report, starting on page 7, Your Honor. These are his opinions. And he offers these opinions to a reasonable degree of medical probability for each of the plaintiffs. Now, UNFW, its concern is Belsky and Haley, because they're concerned that Belsky and Haley, of course, consume real water retail bottles as opposed to, or in addition to, 5-gallon jugs. But the opinions are here. And this report indicates the amount of information by reference reviewed by Dr. Hudson in arriving at his opinions. If we go to Exhibit 25. Mr. Neale indicated that perhaps augmentin could be a source of Mr. Belsky's acute liver injury. It's strange because while that could be, augmentin could be a cause of a liver injury, there's no expert that's offering the opinion that Mr. Belsky acute liver injury is related to augmentin. Mr. Neale's expert, Dr. Dara, doesn't do so. Certainly, Dr. Hudson doesn't believe it is the case. And this is one of those situations where it could be this, it could be that. Now it's augmentin. Perhaps Mr. Neale is telling us they're dispensing with this whole kratom idea. And if he's stipulating to that, then great.
We still like kratom, Your Honor.
As I suspected, Your Honor.
No stipulation.
As I suspected. But there is no evidence in this case that augmentin caused Mr. Belsky's liver injury, and certainly there's no expert offering it to a reasonable degree of medical probability. Now, Dr. Hudson addresses with Dr. Dara, which is D-A-R-A-R, the doctor retained by UNFW, her suggestion that kratom could have been the cause of it. If you could go to Hudson 61, Chris. And this print is small, Your Honor. If you could highlight this section, Chris. Can you put yellow at the top of this paragraph, first sentence? Now, Your Honor, you can see the differential diagnosis was considered by Dr. Dara. And we've already had, based upon the original report from Dr. Hudson and this report, that based upon his diagnosis, based upon his review of every possible cause, it wasn't kratom. It wasn't kratom by virtue of him drinking tea or supplements or anything else. I mean, green tea was suggested, Your Honor. I mean, that's how far the defense will go to point to something other than what's the obvious. I was somewhat tickled yesterday night, sitting there for so long, thinking about the similarities, of substantial similarity arguments. And, Your Honor, I have to tell you, I thought about this perhaps as much as the court did, maybe not as much. And the court was discussing, it's just the consumption of water we're talking about. No consumer expects to get hydrazine in their bottled water. And when Mr. Hoffman was discussing, well, it's got to be similar injury, it's got to be consumption of the water, and none of these other reports should come in, or prior incidents should come in. And Your Honor, I was thinking to myself, I could see if Mr. Pepperman came in here and there was an incident report where someone threw the bottle of water at someone and hit them in the head, causing some kind of closed head injury. That would probably be an incident that we could all agree would not be substantially similar, or even remotely similar, other than it's a bottle. Here, Your Honor, our expert, Dr. Hudson, not only reviewed the medical records, not only reviewed all of the reports, medical bills, the depositions, he considered their UNF doctor's report, her differential diagnosis, if we want to call it that, and came to the conclusion that hydrazine, of all the possible causes, was the only item that we knew identified in the water that could have caused this injury with these plaintiffs, Your Honor. The only one was hepatotoxic, Your Honor, in his opinion. And so when I listened to Mr. Neale go to the point where he would use and support Dr. Friedman's position after Mr. Hoffman crucified him about an hour ago, in support of his position against Dr. Hudson, it's amazing to me what UNFW will do in an attempt to perverse the Nevada Supreme Court decisions in this related to this topic, Your Honor. Hallmark, under no circumstance, would support not allowing Dr. Hudson to give a diagnosis or a causation opinion based upon a differential diagnosis, which is a reliable methodology, Your Honor. And I don't believe Mr. Neale is suggesting that a differential diagnosis is not a reliable methodology. But if he is, then Dr. Dara can't do it as well, Your Honor. Now, if you look at Hallmark, and if you could turn to page 4 of our report, Chris, of our opposition, I'm sorry. Go to lines 18 and below. Stop there. Your Honor, we discussed NRS 50.275 and what the witness must satisfy the 3 requirements. Certainly he's qualified, that's item number 1, the qualification requirement. Number 2, his or her specialized knowledge. We've gone through his qualifications and the foundation for his current opinion, Your Honor, and how those opinions would assist the trier of fact in this case. And then finally, his or her testimony must be limited to matters within the scope of his or her specialized knowledge. Certainly, he is a hepatologist, Your Honor. He's giving that type of an opinion regarding acute liver failure. It certainly fits within the Fernandez case that we cite in our opposition, page 108, cite 108, Nevada 963. Now, Your Honor, I want to touch upon what Mr. Neale said related to the deposition transcript of Dr. Hudson. And I want to start on consumption and exposure, because I think this is a point that has been glossed over, I think on purpose, Your Honor, by the defendant. And I think it's important for the court to understand, because of the amount of, this deals with the amount of retail bottles consumed by Mr. Belsky and Mr. Haley. Your Honor, if we could go, I'm sorry, Chris, if you could go to page 124 of Dr. Hudson's deposition. So, Your Honor, we've argued, Mr. Neale and I argued quite a bit on the motion to strike. And I bring this up because UNFW's seemingly main argument is that Haley and Belsky did not consume enough real water vis-a-vis retail bottles to suffer acute liver failure. And one of the things that Mr. Neale admitted to while we were arguing the motion to strike is that we've not received any cash receipts, paper or electronic, on Belsky, and we've not received any cash purchase data on Haley when it does not include the use of his employee ID or credit card. So, Your Honor, Dr. Hudson was asked about the
I just want to make sure I'm not interpreting this wrong, and it's not a question for you. I did take a look at the supplemental documents that were given to me that were produced pursuant to Rule 16.1, and the way I kind of interpreted it, you can tell me if I'm wrong or not, they appear to be gross sales for the specific stores on a day-by-day basis as to the real water. Am I incorrect in saying that?
I think the only suggestion, not correction, that I would make, Your Honor, is that it wasn't day by day, it was, as I recall, annual.
Okay, all right, I'll go back and take a look, but I just wanted to make sure I wasn't missing anything.
Oh, yeah.
Because I did take a look at it. It might have been this morning, might have been yes, I don't know, but I looked at it.
And I don't know, well, the court is otherwise correct.
Okay, thank you.
So you'll learn through this, Your Honor, that Mr. Neale's admission,
Yearly, okay.
his admission is also borne out in the deposition testimony here. And so, page 124, the witness being questioned by Mr. Neale says, I don't think he could buy, this is Here we go. Question number four, line 4, Your Honor. Do you agree that there's no evidence he bought it at Whole Foods in 2018? We're talking about real water bottles, Your Honor. The witness says, Dr. Hudson, there's no purchase records. Mr. Neale says, yes, sir. Does that mean he didn't buy it there? I don't think so. I think he could buy it without a purchase record. Perhaps he bought it with cash. Right, at that point, though, we're getting down to a fairly de minimis level. I don't know that. I don't know how much he was drinking. Did you ask him about cash purchases? I did not. Now, I bring this up because Mr. Neale knew when he questioned him, although we didn't know this, that we did not have the purchase data resulting from cash purchases. And we still don't have it, to this day.
I understand.
And it goes back again to page 135. This comes back up again in terms of Belsky. So go to 134. Can you put 134 and 135 on the same page, Chris? Split the screen for me.
Yes, sir.
Thank you. So, Your Honor, at line 17, page 134, he asked, how much real water did he drink? So then the question, right, here's my question. You believe that the purchase records are an accurate reflection of what he purchased and consumed on the job? I'm sorry, we're talking about Haley. No, sir. What I believe is the purchase records show what supplement drinks he drank, because the purchase records show everything. I don't know that. Next question, line 2 on page 135. Why would it be different? I don't know. I just have to leave the possibility open that things could be missing because we know the purchase records can miss things, right? How do you miss things? First thing right out of his mouth after that is cash. If you pay cash for things, it doesn't show up on the purchase record. And then, of course, Mr. Neale retreats to get your employee ID card. Now, Your Honor, when it comes to the exposure analysis under the case law, we're entitled to know the cash purchase data. We don't have it for Belsky, we don't have it for Haley, and he's admitted that we don't have it. If Mr. Haley did not use his ID card, we don't have that information. Mr. Belsky, of course, didn't have an ID card because he didn't work at Whole Foods. So if he only used cash as opposed to a credit card, we wouldn't have that purchase data or purchase history. So right now, we're stuck trying to defend an issue on exposure amounts without having the full universe of documents related to the purchase data. And I bring that up, Your Honor, because in 3 cases that I've been involved in, one that went up to the Supreme Court, the CCSD case, the other, which was in front of Judge Levitt, the other in front of former Judge Gonzalez, during trial, the day before trial started, me and Mr. Kemp here, after discovering that phone records had been destroyed or not produced, on the day before trial started, Judge Gonzalez held a 1-day evidentiary hearing, which we handled. The third case that I can think of, Your Honor, was in front of Judge Weiss, which was a year ago, 2 days before the trial, or 3 days before the trial started. We found documents that had not been produced, and Judge Weiss says we're going to start the trial right after the evidentiary hearing is done. And that evidentiary hearing took 2.5 days, and then the case resolved. The point being is, this information regarding cash is extremely important. Dr. Hudson, in an attempt to further support his opinion, was questioned extensively by Mr. Neale. Mr. Neale, knowing that the full picture on purchases and exposure not being produced, had been produced. Because this deposition took place on June 9th. Remember what Ms. Anderson said in her affidavit. They didn't produce the information until June 21st. And then Mr. Shank said that the metadata on the spreadsheet that Mr. Shank prepared actually indicated it was created on June 7th. So we have a metadata indicating The report was done on June 7th, or created June 7th. The deposition's taken June 9th. They don't produce it till June 21st, and to this date, we still don't have the cash information. Now, with all of that said, Your Honor, Mr. Neale, in his deposition of Dr. Hudson explains all of the documents he reviewed in preparation for his opinion, in addition, of course, to the interviews he had with each of the plaintiffs. And so you could go, Chris, to page 28 of Dr. Hudson's deposition. And we'll go from 28 to 29. At the bottom of 28, it says here, and this is Mr. Neale asking him about the materials reviewed. And so, question starting at line 23. So it looked like you just kind of categorized things. You got medical records on all 7 plaintiffs, correct? Correct. Fact sheets on all 7 plaintiffs, correct? Billing records on all 7 plaintiffs, correct? And then a variety of documents listed on the next couple of pages. And he says that's right. Then he also says, go further up, Chris. And then depositions beginning on item number 29. I just want to confirm that you got all of the plaintiff's depositions and then one of the Blaine Jones depositions. Is that right? That is correct. This is the enormity of the documents reviewed by Dr. Hudson in formulating his medical opinion, John. Now, during the deposition, Mr. Neale spent some time, I will say, going through turmeric and crepe. And if you could go to page 42 of the deposition, Chris. And we'll start at line 7, Your Honor. So curcumin, Your Honor, is I guess the real effective ingredient of turmeric. I'm looking at Mr. Neale because
I don't touch the stuff, but.
Okay, good enough. And so the question, so Dr. Hudson says, you know, turmeric has been used for centuries in Southeast Asia with safety. It's been proven in multiple studies, hepatotics, and hepoprotective effects, antioxidant, antiplastic, and you know, there's very little in the literature that implicates turmeric as a damaging medication to the liver. So to me, I felt there was no reason for me to add up what he was taking because it was irrelevant. It's obvious that real water is the real culprit on this gentleman's hepatic problem. If you could go to the bottom of page 44. Mr. Neale moves from turmeric to kratom, but he'll come back to it later in the deposition. So the next question on line 25 says, what did Mr. Belsky tell you about kratom he was consuming? And he says that he used it as a tea, which is typically how it's used worldwide. Again, kratom has been used for centuries for medicinal purposes. So about every 2 to 3 days, he would have some kratom tea. Not multiple times per day, but every 2 to 3 days. So in terms of his consumption or use of kratom, Your Honor, there's been no doctor who has indicated how much curcumin is in each glass of tea. And I say that because Mr. Neale would have plaintiffs try to figure out how much hydrazine was in each bottle, given the testimony we've already, or the arguments and testimony we've had about Mr. Marlowe, and how indefinite and imprecise he determined that the amount of ingredients would go into the concentrate, John. And the other struggle, which I think both Mr. Kemp and Mr. Pepperman tried to suggest to the court or indicate to the court, was once the water is consumed, how do you know how much hydrazine was in the water that ultimately caused the acute liver injury. It's gone, it's been consumed. The person's in the hospital. There was no indication prior to 2018 that hydrazine would have been contained in the real water bottles. And so no doctor was looking for it at the time. It became clear in 2020, and then retrospectively, when you look at the MMWR report, you see spikes in 2018 and 2019, not as elevated as in 2020, but you still see spikes in that report, Sean. Now, Dr. Hudson indicates, and I don't think anyone disagrees with this, that hydrazine, given the sufficient exposure, is hepatotoxic. And he gave that opinion on pages 70 through 73 of his deposition. If you could turn to page 7. And this is how he explained it, John, which he did a better job than I just did. He said, again, hydrazine was not considered as a part of the whole situation. Real water or hydrazine, and there's no safety record of hydrazine. Hydrazine simply is a bad thing. No matter what way you look at it, hydrazine is a bad thing, whereas turmeric and kratom both have beneficial uses. He considered the top culprits by defendants expert, kratom and turmeric, when he gave his decision, when he gave his opinions. Dr. Dara doesn't do the same, and we can deal with that at the time of trial. But certainly, Dr. Hudson performed a differential diagnosis and considered all possibilities. And then Mr. Neale says, I want to be clear, I'm not asking you to agree with their diagnosis. I just want to make sure we're reading the records the same way. He said, okay. Go further up, please. Here we go. The witness talking about Belsky and Haley's diagnosis and perhaps having dilly from a supplement. Dr. Hudson says, I disagree. I would say they were not diagnosed with that, but it was brought up as a possibility in the medical records. And Mr. Neale says, okay. He said, that's a difference. Hydrazine has no beneficial use. He said, that's correct. He said, is it prescribed to cancer patients? Well, no. Well, hydrazine has been used in the past in that regard with no benefit. Hydrazine basically is rocket propellant, which is where Mr. Kemp got it, which is simply true. He says, okay, and there's no beneficial use. He said, hydrolysine is not prescribed as the vasodilator to bring down blood pressure. It is hydrolysine. Hydrolysine is. And this metabolite or apparent, which is the discussion that Mr. Neale had with him. And talk about hydrolysine, he says he doesn't know if it's a hepatotoxin, but he certainly comes back. Go further up to this position, starting at line 19. We don't really know what the lowest dose of hydrazine is that causes damage. None of that has been shown in the medical records, in the research records. So we don't know what the lowest dose is. And plus, we don't know what is the individual tolerance of each person. This is the question about idiosyncratic considerations, Your Honor. Everyone is different. And I think the comparison was perhaps Mr. Neale could drink a fifth of vodka and not get drunk, and I could have one glass and potentially get drunk. And in fact, in this
Not
way,
drunk, liver cirrhosis.
So he says, it's just like alcohol. You may be able to drink a fifth of vodka per day and have no liver damage, but then there's other people out there that drank much smaller amounts of alcohol and have liver damage. So there's an individual susceptibility to any of these substances that we're talking about. Your Honor, I point out some of this back and forth with Mr. Neale, Dr. Hudson, because Mr. Neale took sound bites and snippets, but when you consider the entire deposition as a whole, Dr. Hudson squarely supported his opinions of why hydrazine caused both Mr. Belsky and Mr. Haley's acute liver injury. And I think Mr. Neale corrected himself somewhat by discussing the latency period. But in terms of latency period for Belsky, we've shown you what his mother, Maria, testified to under oath. We've also given you previously, Your Honor, and I don't know if you want to go back through it. But in terms of Mr. Haley, Your Honor, we have two, I believe, current Whole Foods employees who testified that Mr. Haley was drinking real water within the spring and summer of 2019, very near the time he went was hospitalized, and he testified as such. And his fact sheet supports the same. So in terms of the latency period, I don't believe there is an issue. I think there's more than sufficient evidence to support that their acute liver injuries occurred within the period indicated by Dr. Hudson. Your Honor, there's a few more things, but I see it's 5:03.
Yeah,
I'm more than happy to finish up tomorrow.
yeah, we'll finish up tomorrow.
Thank you, Your Honor.
And ma'am, what,
Or Thursday.
We're not coming in tomorrow, we're coming in Thursday at 10:30.
Oh, that's right.
so we're not coming in tomorrow? It's Thursday.
We're here Thursday morning. Your Honor.
That's good, I can finish up a minute later.
There we go.
I'm sorry, 10:30 on Thursday?
Yes.
All rise.
Everyone enjoy your evening.
Thank you.
Thank you.